The Aging with Options show is about seniors and for seniors and their loved ones. Our passion is to provide interesting, timely, relevant content for seniors and their families in the Louisville area. I'm Chris McCutcheon. Legal issues facing seniors is the topic of our conversation today. Elder law attorneys Bernie and Rhoda Fowler are my guests. Bernie is the managing partner of Kentucky Elder Law, Kentucky's largest elder law firm in Kentucky. Bernie and Rhoda have been sharing some valuable information on navigating much of the legal landscape that today's seniors are facing, and particularly we've been talking about advanced directives and the difference between living wills and DNRs. Bernie, for the next segment, to start off, let's talk a little bit about the probate process, certainly an important subject of importance to seniors as they face that process and family members face the prospect of having to go to probate court. Tell us a little bit about that. Probate, of course, is the process of how your assets pass to your heirs at death. What do seniors and their families need to know about the probate process? Well,
first, it is the legal process where your will is presented to a court and it has to be admitted, which means the judge has to believe it was properly executed, and there's a format for executing it. And then once it's admitted, they appoint a personal representative, used to be called an executor or executrix, and that person will carry out the wishes in the will. And the will is where you write down who gets your stuff. You know, I want my furniture to go here. I want my money to go there. I want my real estate to go someplace else. In Kentucky, it's much easier to handle probate and do probate in Kentucky than most other states in the United States. It's a very simple form. It's a streamlined process, not a difficult process, as long as the kids aren't all fighting and producing three different wills and, trying to claim something of that nature. Not particularly expensive, and it's all wrapped up in a little over 6 months.
6 months.
Creditors, once you open the estate, that means the judge signs off. Creditors have 6 months to show up. Clock starts running. So after the 6 months is gone, a creditor can't show up. At that point, the attorney would file some papers with the court. Everybody who gets money would sign off as to what they're getting. The personal representative distributes the asset, and the estate is closed. So the creditor comes back a year or two later and say, hey, you owe $50,000. Too bad.
Gotcha.
You had your chance and you missed it.
Do all assets pass by way of a person's will?
No, it's very important. Not all assets pass by will. There are certain assets called non-probate assets. For example, assets in a joint bank account are not a probate asset. And this is where families often get messed up. Let's say mom has 3 kids, 1, 2, and 3, and she wants daughter number 1 to help her sign her checks. So daughter should have a power of attorney to help mom sign the checks. But instead, mom often puts daughter on the account, usually at the advice of someone, and now mom dies, and daughter, as a joint holder, owns all of mom's money. Daughter's nice, she shares it with kids 2 and 3. Daughter's not so nice, she tells them to take a hike, and you have a problem. So anything in joint tenancy will not pass through will. Anything with a beneficiary will not pass through will. So, for example, life insurance will pass by beneficiary. IRAs and annuities almost always pass by beneficiary. Anything inside a trust will pass through the trust to the trustee. And often there are some disadvantages, can be some advantages or disadvantages to that, although trusts are often overused in Kentucky. So not everything goes through, but it is good to run assets through the will because the court is monitoring the entire process.
In addition, it's important for people to know that the power of attorney ends the moment the person dies. Once the person has died, there is no longer a power of attorney, and nobody's in charge of the person who's deceased's affairs until the personal representative is appointed. So there's a period of time when nobody is legally in charge. And it's also important for the personal representative to not pay any except funeral last expense bills until the end of the 6 months to make sure there's enough money to cover all of the different bills. If not, the personal representative will need to pay each a proportionate share of the money that's there.
So don't pay those bills until after the probate process.
the one bill you can pay is the funeral bill because that's a preference item. That comes ahead of everybody. And there's some other things, but you normally, if you have $50,000 of bills and $30,000, you don't pay anything till you know what all the bills are going to be because it's going to be prorated. If you have $30,000 worth of bills and $500,000 and you're not expecting anything new to come in, you pay the bills, it's okay. Now, one thing where people get very excited, they say, well, Mom died and we're not in court yet and we have to pay the credit card. And I say to them, why? I mean, are you worried about her credit rating? You just, people are going to wait. They deal with this market. They know they die. They know estates have to be opened. You may not be familiar with the process, but the creditor is.
Bernie, you said it's good to go ahead and run all assets through the will, even those that are in joint tenancy or where there's a beneficiary. You're saying to
no, that's not what I said at all. No, don't. Things with a beneficiary should stay that way. For example, life insurance has a beneficiary. So let's say there are creditors. You almost never want to make the estate a beneficiary because life insurance is not subject to the claims of creditors, whereas estate assets are. So anything that has a beneficiary, you pass by beneficiary. So we're not looking to run things through, but anything that does run through the estate at least is going to be monitored by the court because that all has to be, you have to prove up at the end of the process what there was and where it went, and the judge signs off on it.
So going through the probate process when you have several children makes it such that you're not going to have one child accuse the other of not giving out a fair share or doing what they were supposed to because the court is monitoring it.
Okay. Court's monitoring the process.
Yes, right. And probate, as Bernie said, in Kentucky is really easy, and you can have a lawyer help you, and you don't even need a lawyer for the process.
You don't have to have a lawyer for the probate process.
You don't have to, but it's a formal process. You want to talk to somebody who knows what's going on. That's
right. It's helpful, but it's not mandatory. In some states, it's mandatory.
And even if you're trying to take that on by yourself, about a 6-month process from start to finish.
Right, and there are just ways to make a mistake. Now, if the personal representative is handling the estate and you're a beneficiary and you think they're doing something improper, you can go before the court, and usually would want a lawyer for that, and ask to replace the personal representative with someone else, either another family member or an outside party. There is a thing called a public administrator. So if there is no personal representative, the judge can appoint this firm, which is in Louisville, or if there's just a family feud, they'll appoint a neutral party, and they will sort it all out.
Very well. Okay. Bernie and Rhoda Fowler are my guests today. Bernie and Rhoda are elder law attorneys with Kentucky Elder Law, the state's largest elder law firm. We're discussing legal issues facing today's seniors and their families. We'll take a quick break, and we'll be back right after these messages with Bernie and Rhoda and more topics of interest to seniors in the Louisville area. Brought to you by BrightStar Care. You're listening to Aging with Options on 970 WGTK.